Hey everyone, if we're meeting for the first time, my name is Paul Vojchehoske and welcome to Nebraska Landlords YouTube channel, where my mission is simple, and that's to enhance the landlord-tenant relationship. Today's video is sponsored by that red subscribe button, so do me a favor, please give this video a thumbs up, then click on that red subscribe button, then click on the notification bell, and please, please, please stay informed of what's going on in our industry. Appreciate that. Sign up for in today's video, and the next several videos, we're going to start a series on dissecting the Nebraska Landlord Tenant Law itself. So many Nebraska landlords have no idea really what's in the law and how it's applicable to them, and the same is true of tenants. This is going to be pretty generic, meaning it's going to be very beneficial to Nebraska landlords, property managers, and tenants. Because I really believe that the landlord-tenant relationship is black and white if everyone adheres to their obligations and duties under the Nebraska Landlord Tenant Act. So when we're done with this entire series, we will have covered Nebraska Revised Statute 76-1401 through 76-1449. I am not going to cover every single citation. We are going to hit the major, the high points of the law itself, including notices and 30-day, 7-day notices and all of those. But in this video, this really is going to discuss the preamble of the statute, right? So we're going to start with 76-1402. What is the purpose of the Nebraska Landlord Tenant Act? And the purpose is to simplify and clarify the landlord-tenant relationship. And I will be honest with you, I get a lot of people. Tenants believe that the landlord-tenant law in Nebraska is very pro-landlord, and just about every landlord in Nebraska thinks that it's very pro-tenant. And I have seen almost every state's landlord-tenant laws, and Nebraska is pretty fairly balanced all in all. All right, but it does establish, and I think it does a good job of establishing the duties and the obligations of all the parties, the landlord and the tenant. Now, how that plays out in a courtroom, that is a different story. We all know as landlords and managers, when you step foot in that courtroom, a judge does exactly what a judge wants to do, regardless of what the law says. And I've seen it done numerous times. However, the purpose of the law is to simplify, clarify, and establish everyone's rights and obligations. And ultimately, it's there to encourage happy housing in the state of Nebraska. All right, so that is the preamble, if you will, or the purpose of the Nebraska Landlord Tenant Act. Let's take a look at 76-1408. Who is excluded and what types of properties are excluded? We're going to go through this real quickly. But someone who resides in an institution, such as a hospital, nursing home, a homeless shelter, those type of organizations, they are excluded from this law. Post-occupancy. Post-occupants are also, that relationship is excluded. And the post-occupancy relationship is an occupancy that's been created as a result of a purchase agreement. So let me give you an example. You own a house and I want to buy your house. We do a purchase agreement. It goes to closing. And in the purchase agreement, I, as the buyer, agreed to allow you to stay in the property for 2 extra weeks. You're post-occupying, post-closing, for whatever reason, happens all the time on the sales side. That is not intended to be a landlord-tenant relationship. However, it can escalate to a landlord-tenant relationship. Let's say, for example, we agreed that you could stay there 14 extra days. On the 15th day, you don't get out. I want you to get out. Now I actually have to evict you, and I have to serve notices and file restitution order, and etc. That is called, that is what post-occupancy is. And generally speaking, post-occupancy is exempted from this law. Fraternal or social organizations operated for the benefit of its members are also excluded. Let's say, for example, you belong to a group or an organization, a club, and they have a lodge on the lake, and you're renting that out. That is excluded because it's for their members only. Hotels and motels are excluded. Employees of the landlord are also excluded, and this can extend to property management companies that hire people And as a benefit, they allow them to live on their properties that they manage at a reduced rent rate. That is also part of this. They are excluded from the Landlord Tenant Act. Condo owners, because condo owners have fee simple ownership title, right? So they are owners, they are not tenants. Holders of a proprietary lease, and a proprietary lease establishes the rules and regulations for those that live in a cooperative. Totally separate and different type of video. If you're a ranch hand, let's say you work on a ranch out in western Nebraska and you live on the ranch in a ranch house, that is an example of another type of property and person that would be excluded. And then the last one is interesting. I don't know the history behind this, but a lease for improved or unimproved land for a term of 5 years or more, or I'm sorry, more than 5 years, they are also excluded. And I don't know the history there. If you do know, please put it down in the description or the comment section. That would be awesome, because I don't know the history there. 76-14-10 is definition of terms. Definition of terms are very important in the construction of any statute. In the Nebraska Landlord Tenant Statute, we have terms like good faith and dwelling and rent and landlord and roomer and rental agreement, and they all are defined in a particular way, and it goes towards the applicability of the statute. So when you're reading a statute, you have to know the definitions of these terms. I'm not going to go through each one. I am going to go through each slide. I'm going to click through the slide. So I highly encourage you to put this video on pause so you can read the definition of each term. It's going to be so important that you do that as we move forward into the follow-up videos when we get into the meat of the Nebraska Landlord Tenant Act. You're going to have to know these terms. So let's take a look at the first set. We have active domestic violence, action, building and housing codes. Again, put this on pause and read through each one of these definitions. 4 through 8, we have dwelling unit, good faith, household member, landlord, and organization. Number 9 through 12, owner, person, qualified party, and premises. 13 is rent, 14 is rental agreement, 15 is roomer. And I cannot tell you how many calls in a year I get regarding roommates. Unbelievable. And then 16 is single family resident, and 17 is tenants. These terms are very important to know and understand, and you're going to need to know them as we proceed with future videos. 76-14-11 is the obligation of good faith provision of this law. Now, all parties in the landlord-tenant relationship, they're obligated under this law to perform under good faith. So let me give you an example. I'm the landlord and I convey or I transfer the legal right of possession to you. There is an obligation by me to not disturb you and harass you because you have the right of quiet enjoyment. There is a good faith understanding that I'm going to perform in a way that's not going to be harassing. Likewise, as a tenant, you have a good faith obligation not to destroy my rental property. You have an obligation to pay the rent on time, to let me know if there's items that need to be fixed. This is all done in good faith. And why good faith is important in terms of this law is when we get to different parts of the Nebraska Landlord Tenant Statute where there are punitive damages available to the injured party, good faith, the performance of good faith comes into play here. 76-14-12, unconscionability. What is unconscionability? Well, it simply means that a judge has determined that your lease agreement, for whatever reason, is so outlandishly ridiculous that they're going to invalidate it, and they are not obligated to enforce the agreement. There are several reasons how this can happen. And it can be that a judge feels that the entire document is unconscionable, or even just one single provision, if the judge feels that it rises to that level. The biggest issues that I see, or where landlords get into trouble, is they put things in the lease that shouldn't be in there because the statute specifically says they can't be in there. A couple of examples. Number one is you cannot put anything in a lease agreement that requires the tenant to waive their legal rights to, let's say, file a fair housing complaint against you, or to not turn you into code inspection for housing issues. Those are specifically prohibited in the statute. Another one that's prohibited in the statute is, and I see this all the time, landlords will put in there that if the tenant and the landlord ever have to go to court, then the tenant agrees to pay for the landlord's legal fees. That is something that specifically the statute says that you cannot include in there. And I have seen over the 2.5 decades of me doing this, several landlords and managers get themselves into trouble and get their lease agreements thrown out because of those things that they've included in their rental agreement. That is the doctrine of unconscionability. Don't forget, folks, it is so important to stay informed. Down below in the description section is a link to give me your email address so you can stay informed of what's going on and be notified every time I put out a new video. That's it, everybody. See you in the next informative video.